the two contestants have already flipped coins. So speaking aft today, or affirmative, is Camma Duhamell, contestant W6. And speaking neg today is Hannah Geiss, contestant W7. Our judges today, judges, if you please raise your hand, identify yourselves to our competitors and to the rest of the audience. AC1, Heather Beach. E3, Tom Sweeney. H1, Linda Arney. N7, Steve Lindenman. And B11, Priya Sarogi. Okay? All right, so with all that being said, again, congratulations to our two finalists, and you all may begin.
Before we begin, I'd like to give a few thank yous. First of all, thank you to all of the people that helped organize this event and all of the judges who persevered through all the delays. Thank you to my coaches for their support and wisdom. You truly keep the spirit of debate alive, Mr. Lowry and Mr. Coots. And finally, I want to thank my teammate and best friend, Hannah. I'm so proud of you, and I'm glad to be here one last time regardless of what happens. Thank you. All the judges ready? Okay, let's begin. I stand in firm affirmation of the resolution resolved. Plea bargaining ought to be abolished in the United States criminal justice system. I have a few definitions. Ought from Merriam-Webster is used to express obligation, and obligation from Oxford is a course of action to which a person is morally or legally bound. Plea bargaining from Cornell Law are agreements in which defendants agree to plead guilty to some or all charges against them in exchange for concessions from the prosecutors. And the criminal justice system from Oxford is the system of law enforcement involved in apprehending, prosecuting, defending, sentencing, and punishing those suspected or convicted of criminal offenses. My value today is Immanuel Kant's justice. Kant's justice considers what is inherently right so that an understanding of true morality can be formed before it is applied to the real world. It values protecting rights and can be measured by what rationally ought to exist or the moral standards that society agrees upon, such as in the social contract or the Constitution. We are morally obligated to not act in ways that perpetuate injustice. Plea bargaining is an inherently unjust means to achieve greater efficiency in the criminal justice system and does not have a clear moral premise. Continuing plea bargaining prevents progress towards true justice in the U.S. system because it allows us to ignore morality in favor of streamlining the efficiency of the current system. Therefore, there is an obligation to abolish plea bargaining in order to fulfill justice. Kant's justice is true justice because it bases whether an action should be performed or not on whether it is right, rather than whether it produces favorable outcomes, because good outcomes do not always reflect just decisions. And the resolution only asks what we ought to do. We ought act justly. Therefore, the efficacy of plea bargaining is not as important as its inherent moral worth in terms of whether it ought to be abolished. My value criterion will be Kant's categorical imperative. The categorical imperative has three important ways to ensure moral action. Firstly, it says we should act only in ways that we should reasonably say could be universal for all people in that situation. Secondly, we should respect all people as intrinsically valuable ends in themselves, with equal dignity and respect, not as merely means to other ends. And thirdly, we should rationally respect the autonomy of other people. These are the parameters that determine what is inherently right. Continuing to use plea bargaining in the U.S. cannot be justified because it fundamentally inhibits the pursuit of justice, which is the central aim of the justice system. Plea bargaining continuously violates individual justice and does not consider morality first. It therefore corrupts justice in the entire society. This problem occurs in three main ways. 1, it prevents the access to a fair trial. 2, it allows for admitted criminals to escape deserved punishment. And 3, it allows for innocents to be manipulated into confession by a corrupt system. These are the three facets of my one contention. Contention 1, plea bargaining is unjust. Subpoint A, prevents access to a fair trial. Plea bargaining is unjust because it gives the defendant the illusion of choice. Because the process is designed to benefit outside parties, being the prosecutor or the government at large, its focus is not on ensuring that the defendant receives the fair treatment that he is due. The Center for American Progress states that a majority of criminal defendants cannot afford a good lawyer, 80 or 90% in some estimates. Plea bargaining is inherently coercive because it guides people, often minorities or those with low income, towards violating the Fifth Amendment, protection against self-incrimination, regardless of their innocence, out of fear of worse consequences that are staged by the prosecutor. By preventing trial, plea bargaining prevents the defendant from maximizing his chance to be set free or to receive a better outcome than what the plea deal offers, which is why the rights that plea bargaining violates are valuable in the first place. They protect individual worth. By pressuring the defendant with choices that may be the only rational option to secure the best solution for himself, plea bargaining by nature strips people of their constitutional protections of a fair trial and against self-incrimination, which are a prerequisite to the application of justice in society. Plea bargaining is a dismissal of rights, which is in itself unjust and therefore cannot confer justice to the defendant or society. Subpoint B, criminals escape deserved punishment. Not only are defendants denied justice through the dismissal of their rights, but also when it is due in return for a crime. Plea bargaining allows defendants to admit that they acted unjustly and without even remorse escape appropriate or any consequences at all. To maintain justice in society, there must be equivalent consequences for violating its laws. Plea bargaining inherently promotes unjust courses of action and thus general injustice throughout society. Finally, subpoint C, innocents suffer. A system that perpetuates the false conviction of innocence cannot be considered just. The Department of Justice's outline of plea bargaining provides no standards for determining that the defendant actually committed the crime and is not admitting out of intimidation or other factors that would prevent him from being rightfully exonerated. Plea bargaining's expedited conviction allows for a lack of sound evidence that harms innocents who would otherwise have access to a fair trial under the Constitution. According to The Economist, researchers demonstrate, based on an actual case of plea bargaining, how common false confessions are. Students were asked to solve logic problems. An accomplice of the researchers asked half of them for help. All were then accused of cheating and offered a plea bargain to avoid penalties. Nearly 90% of those who had aided confessed, but so did a majority of those who were innocent. According to the Cato Institute, prosecutors use their power to pressure people who have been accused of a crime and are presumed innocent to waive their right to a trial and admit guilt. Prosecutors admit that this is what they're doing, and the Supreme Court has approved these tactics in the case Bordenkircher v. Hayes. It said there was no constitutional problem with pressuring the accused to waive his trial and admit guilt. There is no illegal coercion so long as the accused is free to accept or reject the prosecution's offer. If prosecutors are legally allowed and even encouraged to coerce defendants into accepting plea deals on their terms, often in 3 minutes or less, and without judicial review, then defendants aren't really free to reject the offer. Plea bargaining is coercive, violates crucial constitutional rights, and discourages the use of thorough evidence to incriminate that is a part of due process. Its standard of violating justice on the individual level undermines justice of the entire system because its basis is not morally sound. With all of these reasons considered, I must urge a ballot and an affirmation. Plea bargaining ought to be abolished, and I'm now open for cross-examination. Are all the judges ready?
Let's start with your value of Kantian justice. How is this going to be achieved specifically as the result of a ban?
So, Kantian justice essentially says that we should never act in ways that are unjust. And if we're allowing any degree of plea bargaining to exist because it's proven unjust, then we're not fulfilling justice.
Is there a fundamental difference between addressing injustices on a case-by-case basis and creating a justice system that consistently yields just outcomes?
Yields just outcomes?
Yes.
Well, a just system that consistently yields just outcomes would consider cases on an individual basis.
When Kant describes justice, is he talking about justice at an individual level or justice at a societal level through institutions like the criminal justice system?
So Kant talks about objectivity a lot, but he also talks about the social contract, for instance, being the will of the people in order to determine what justice is. So because that social contract is composed from the people's wills and it affects people individually, it considers both societal justice and that which affects the individuals.
So if the Supreme Court has on multiple occasions deemed plea bargaining as acceptable, then would Kant agree that because the social contract accepts it, that it is just?
So perhaps if plea bargaining could continuously be proven just, but a fundamental part of the Constitution and of a social contract is that it's fluid to the people's will. So if they determine plea bargaining is unjust for the reasons that I provided, the social contract would logically be shaped to reflect that. So it's changeable. It's not rooted only in what's happened in the past.
Isn't a trial also fluid in that way?
Perhaps, but as I provided in my constructive, there's a lot of circumstances in which a trial isn't beneficial.
Okay, so is a trial fundamentally better than a plea bargain?
It has checks and balances. It depends on the situation. Plea bargaining does not have the degree of checks and balances that a trial has, because a trial has constant access to a judge, constant access to the lawyers, and the jury's checks, whereas a plea bargain is often occurring in a lot less time and without proper consult outside the prosecutor's terms.
Okay, let's talk specifically about your evidence in your third subpoint, that Florida study that was evaluating students. Wouldn't you agree that students have a lot less at stake considering they aren't going to be incarcerated as a result of their decision?
So if that's proposed as one limitation of the study, there's two important things here. One, this was based on an actual case of plea bargaining that in which a woman was incarcerated for, I believe, 19 years, and I can bring that up in my next speech. And secondly, because it was based on that specific instance of plea bargaining, the study was tailored to reflect that. So even if the stakes aren't as high, the principle is there. People admit for less consequences.
Okay, but this study doesn't actually reflect, this study is not describing plea bargaining itself, right?
There's no way to measure all those instances.
Okay, that looks like time. I'm also going to start off with a couple quick thank yous. First of all, obviously to everyone who made this tournament a possibility. The judges who sacrificed their weekends to come watch teenagers talk about stuff. Tab for running the tournament and getting us through some pretty awful delays and making sure that everything happened the way that it was supposed to. The debaters here who all participated, the coaches who helped them do that, really everyone in this room and school. Secondly, to my school, specifically my teammates for constantly cheering me on, not just through today, but through 4 years of debate. My coaches, Chris Lowry, who has consistently through these 4 years been my cheerleader, Dakota McCoy, who tolerates probably more than he should have to of my obnoxious discussions about case points, and then Mr. Coots, who's obviously an incredible teacher and an incredible debate coach, not only because he's taught me everything that I know about LD debate, but because right now he has 2 debaters in the final round of the state tournament. And then finally to Camma, who is my best friend and classmate, and functionally my debate partner, probably one of the best opponents I'm ever going to have in all of my debate career. With that being said, I will start by reading my own case and then moving on to my opponents. Supreme Court Justice Anthony Kennedy said that plea bargaining is not just some adjunct to the criminal justice system, it is the criminal justice system, which is why I must negate the resolution plea bargaining ought to be abolished in the U.S. criminal justice system. I agree with my opponent's definitions. My value is Aristotelian justice, which contends that each person has an equal right to the most extensive liberties compatible with similar liberties for all. When this is applied specifically to the American criminal justice system, there are 2 important factors that we have to take away. First, we must consider the judicial integrity of the system. Then secondly, we have to consider the ability of that system to effectively achieve its goal. This is why my value criterion is legal pragmatism, which the Internet Encyclopedia of Philosophy defines as a theory that uses reasoning to offer the best possibility for justified and consistent legal practice. Although the concept of absolute justice seems to be a noble pursuit, realistically, the best criminal justice system is the one that does the most good the most efficiently. So in other words, a just system has to operate both correctly and effectively, not just one or the other. Abolishing plea bargaining prevents the system from doing both of these tasks. Contention 1, plea bargaining is necessary. Subpoint A, necessary for justice. Plea bargaining eliminates the threats of major criminals. When plea bargaining occurs in exchange for a testimony, it's in order to convict someone of a more serious crime that was far more detrimental to the society. The sentence of a minor criminal is lessened so that one at a higher level can be convicted. It's proven by CQ researcher that the exchange of leniency and sentences for testimony has consequentially become a mainstay of the criminal justice system. Plea bargaining is the only way in a lot of these instances to actually get a witness testimony that secures the conviction. Plea bargaining solves the cases of countless murders and violent crimes, preventing and controlling crime for all citizens in the society. Subpoint B, necessary for efficiency. According to the United States Department of Justice, 90 to 95% of both federal and state cases are resolved through plea bargaining. If it were to be abolished, 20 times the number of trials that our courts currently face would have to be handled. This is just impractical. Dr. Michelle Alexander of Stanford Law agrees by saying that there would not be enough judges, lawyers, or prison cells to deal with the ensuing tsunami of litigation. It would create chaos. And this isn't just rhetoric and hypothetical statistics. This is exactly what happened in El Paso County after they issued a ban on plea bargaining. After 3 years, the caseload for criminal justice judges had increased by 250%. In fact, it was so extensive that civil judges who were not qualified to handle these cases were forced to take on part of their caseload because of complaints of delays from lawyers and their defendants. This paralysis of the legal process has two very serious consequences. First of all, citizens have to wait exponentially longer awaiting their trial. In El Paso, after the ban, citizens sometimes waited for upwards of a year for their trial, often in a jail cell, a clear violation of their due process rights. Secondly, dismissal rates increased. After a ban in New York, dismissal rates increased by 21%. 10% of all criminal cases were dismissed, meaning that these potentially dangerous criminals were walking free with zero repercussions. Contention 2. A ban on plea bargaining doesn't stop plea bargaining. According to Harvard Law Review, any attempt to abolish plea bargaining will simply drive the practice underground. This is exactly what my opponent is advocating for. This has been observed in every single area that has implemented a plea bargaining ban. In Alaska, for example, 56 to 60% of all defendants still functionally had plea bargains. In El Paso, only 40% of the actual caseload proceeded to a trial. What this means is that all of the detriments and injustice that my opponent thinks is inherent to plea bargaining doesn't end. It gets worse because it's no longer subject to government oversight. We can no longer try to improve this process through reform. It goes underground and it becomes unregulated. Moving on to address my opponent's case specifically. Her value of Kantian justice is only going to be able to be upheld on the negative side of today's resolution because this is the only way in which we create a criminal justice system that can effectively achieve its goals. Even if the goals that she's trying to achieve were absolutely just, they simply wouldn't happen. We would experience delays for specific cases. People's due process rights are denied when we ban plea bargaining, not just because they have to spend upwards of a year in jail awaiting their trial before they're even convicted, but also because criminal cases are simply dismissed, meaning that people walk away with zero repercussions. This also conflicts directly with her value criterion of the categorical imperative, because we aren't instituting a system with universal punishment, we aren't respecting people's autonomy because we're treating them fundamentally different, because the system is not fair. It doesn't treat people fairly because it can't operate effectively. Secondly, in response to her value criterion of the social contract, Immanuel Kant would support the use of plea bargaining because it has been consistently upheld by our Supreme Court as a justified practice. First through Brady v. United States, but also through other courts that helped slightly change and make this process more effective and more beneficial to the defendant in Missouri v. Fry and Lafleur v. Cooper. Moving on to my opponent's first contention, looking specifically at her subpoint A, she says that this prevents access to a fair trial. But what we have to recognize here is that people are voluntarily forfeiting their right to a trial. And specifically, if we were to ban plea bargaining, things wouldn't get better, because the only thing that would happen is that we're only going to make trials happen for people who can't afford to get into systems where plea bargainings would still occur. Currently, reform is in the works. The Supreme Court has consistently been working to make this process better. In response to her subpoint B, she says that criminals will escape just punishment. However, Justice Kennedy says that a lot of the times when we have significant punishments on the books, this is only to be used as leverage during plea bargaining, because he recognizes that plea bargaining is a fundamental element of our Supreme Court justice system. Furthermore, even with the plea bargaining, punishment is still given, and it's just because everyone has the opportunity to plea bargain. Specifically in response to her subpoint C, innocents will be worse off in a system with a ban because coercion will still happen underground without legal oversight, and trials will be sped up and will become less accurate and less effective. I'm now open for cross-examination.
judges ready? Is my opponent ready?
Yeah, go ahead.
Okay, let's begin. So, what does Aristotle value more, the protection of individual rights or net justice to society?
Well, Aristotle advocates that we try to find a balance between these two things. Obviously, we're trying to balance the natural rights of everyone involved. So we have to create a system that can actually achieve that end.
And how does plea bargaining specifically, why is that specifically necessary for that end to be achieved?
Because it's the only way that in the United States today we can process the massive caseload that we have. If we were to abolish plea bargaining, first of all, the caseload of the courts would become so large that they wouldn't be able to handle it, and the trials would become more rushed and less accurate. The juries wouldn't be able to be fully exposed to all of the evidence. And the majority of people, 60% in most instances, would still get plea bargains in some form, but it would be in an unregulated form that would exploit all of the injustices that you've laid out.
So if you say that that's going to occur as a result of banning plea bargaining, then do you acknowledge now that full trials better consider evidence and they better have allocation of resources and time to give the defendant what they're due?
Not necessarily. What we see is that in a system like the status quo, we're consistently reforming plea bargaining to make it a better process. That's why it's been addressed in so many Supreme Court decisions. And there have been changes that have consistently expanded the rights and protected the constitutional rights of defendants.
But what about the inherent premises of plea bargaining? For instance, that the prosecutor is the one who determines the circumstances of the deal. Those don't change with each new...
The prosecutor determines the circumstances of the deal after evaluating the evidence. This is very similar to what happens in a trial. It just doesn't take all of the time and resources away from society that a trial does.
So efficiency in this instance, if we're valuing resources, we're valuing what's doing necessary.
We're not valuing efficiency, we're valuing justice, but we recognize that in order to achieve justice, we have to be relatively pragmatic with what we're doing, otherwise justice will never be achieved.
Why is it inherently valuable to support maintaining the efficiency of the current justice system?
Because if you say that efficiency is irrelevant, then you create a system where you're saying that it's okay for 10% of criminal cases to be dismissed and for people to be waiting for years for their trial.
But not if efficiency is irrelevant. Why is this particular system what we need to be continuing protecting if you acknowledge that there's all of these harms already occurring? Why is there this backlog existing? Isn't that evidence of things that need to be changed in the system?
No, the fact that backlog would exist just shows how much we need plea bargaining in the status quo.
Plea bargaining specifically and no other reforms.
Yes, because a large number of people who are convicted or are going to be convicted are actually guilty. Plea bargaining provides them with an outlet to save society the resources that would be used in a trial when they're guilty anyway.
Okay, thank you. judges ready? My opponent? So as a brief roadmap before we begin, I will just be attacking the negative, defending the affirmative. Let's begin. So, with my opponent's value of Aristotelian justice, she says that it's crucial that we ensure equal rights are given to people. I have two responses to this. First of all, equality is not being upheld by her very subpoint A within the case. She says that it's just, we're ensuring justice in society because we're sentencing worse criminals by allowing people who've admitted guilt to walk free or with lesser sentences not equivalent to their crime, so that they reveal information about these bigger criminals. While that may improve society in some ways, it's necessarily not achieving equality, which is a facet of her value because it's not ensuring an equal punishment for the person who's giving the information in the first place. My second response to this is that the current system issues are not being solved by plea bargaining, and other reforms would be more just. So we can't say that we should do this just because it achieves some degree of justice in society if it necessarily violates justice in other ways. On her value criterion of pragmatism, this is only justified if we prove that improving the current system and making it more efficient or allowing it to function as it currently is just. And even if plea bargaining is the crutch of the current system, it's not necessarily moral in and of itself, and it's not necessarily allowing moral progress to occur in society. On her first contention of plea bargaining being necessary, on her subpoint A, you can cross-apply those responses that it's not achieving equality and therefore it's not upholding Aristotle's prerogatives about equal treatment for individuals in the case of plea bargaining. Secondly, any deficit in justice would be wrong by those standards. And thirdly, if people are equal, then one justice should not be preferred. On her subpoint B, she says that we're achieving efficiency. Necessary doesn't mean just. Just because it's necessary for the current system doesn't mean that it's the right decision. Innocents are still being convicted at a much higher rate when plea bargaining occurs because it has less checks and balances. The judge is not intimately involved with the process, and the prosecutor can make deals arbitrarily based on what they do. That's inherent to the system of plea bargaining. The prosecutor is the one who makes the decisions, and the defendant is often uninformed because of that as a direct consequence. Secondly, she says that people are waiting in trials for jail. It's better to wait and receive justice eventually than it is to have your justice dismissed quickly. And thirdly, she says that dismissal rates increase and criminals walk free. Criminals walk free more frequently with plea bargaining, and they don't receive the degree of justice that they're due because of their crimes. And there's no evidence standards of plea bargaining, so there's no equal consideration beyond a reasonable doubt like with trials. On her second contention, I have two responses. A ban doesn't stop plea bargaining. These shouldn't be considered. We shouldn't pick the lesser of two evils because the resolution is asking us ought. We should do what's inherently just. And secondly, the underground facet isn't a part of plea bargaining inherently, so if it's not inherent, it shouldn't be considered. That's the only thing the resolution is asking. On the other side of the flow, on her value, she says two things. She says the negative is the only way to achieve justice and the system doesn't treat people fair. Two responses. Firstly, waiting and trial is not a fault of a world without plea bargaining. That's an inherent flaw of the system. And secondly, the negative is the world that is the current system. So if my opponent acknowledges that there's flaws within the current system, plea bargaining is obviously not fixing them, and that's not a justification for keeping it. The negative also doesn't treat people fairly because it discriminates based upon who should receive justice in cases of plea deals where, for instance, bigger criminals are being taken down. On her value criterion, she says the courts uphold plea bargaining. The status quo uses a different framework to determine what's moral. That's why they're upholding plea bargaining. They're using the efficiency framework and not necessarily justice in the way that we could be discussing it now. So the status quo that approves it isn't looking at the resolution in the same lens that we are. So it approving it doesn't necessarily mean it's just. And on the first contention, on my subpoint A, she doesn't prove that there's inherent injustice of plea bargaining or that we can't accomplish solving these things with reforms. And on the subpoint B, equal punishment is not being given, which is a prerequisite of Aristotle. The underground is irrelevant because it doesn't concern the inherency of plea bargaining, and trials are better because of their system of checks and balances. And she further drops my subpoint B, so that continues to flow. I must urge a ballot and affirmation.
I'll start by addressing my opponent's case, then move on to defend my own, and I will go over voting issues as I progress down the flow. Starting off with my opponent's value structure, essentially the only response that she has is that the flaws that I bring up are not inherent to the system. But what she fails to recognize throughout her entire last aft speech is that the reality of plea bargaining is very different from the picture that she tries to paint. She tries to say that what the resolution is doing is going to create this system of absolute justice. And what happens when bans on plea bargaining actually occur in the real world doesn't matter, because underground plea bargaining is somehow inherently different than plea bargaining that's administered by our justice system. But what the resolution asks us to do, and what her definition of ought says that the resolution asks us to do, is see what the government has an obligation to do. What is our criminal justice system obligated to do? And it's obligated to do what convicts guilty people and protects society at large. What best balances the rights of individuals in order to ensure that we have a system that can actually efficiently and correctly balance those rights. So unless the affirmative can prove that she is going to correctly balance rights and do that efficiently, she can't win today's round. What we have to recognize today is that in response to the attacks on her value criterion, she basically says that the status quo is unjust. And she says that we should prefer her opinion above the Supreme Court. However, the Supreme Court recently passed a decision in 2012 that gave specific reforms to plea bargaining to expand the protection of constitutional rights of defendants as they move through the criminal justice system. So what we see is that reform to plea bargaining in the status quo is in the works. And the only way that we can allow this reform to continue and to continue to create a better system that accurately and effectively balances the rights of all citizens in society is by legalizing and continuing to allow plea bargaining to occur above ground. As soon as you ban it, you make sure that the most dangerous and most harmful form of plea bargaining will continue to hurt society. Moving on to address her subpoint A, the only thing that she says in response to this is that I don't have proof that reforms work. But the fact that the Supreme Court is making an effort to protect the rights of the defendants proves that what's happening if we continue to allow plea bargaining is inherently more preferable than pushing it underground and allowing it to basically be a legal free-for-all. She doesn't respond specifically to the attacks that I made on her subpoint B or C, so these are going to be two very important voting issues. First of all, the attack in response to her subpoint B, that a ban means that more people escape just punishment, and this is because of the dismissals that occur, because our legal system is just overloaded and can't process these cases. Remember, this would be a 20-fold increase in cases that would need to be processed. When this happened in New York, 10% of cases, criminal cases, were dismissed. This is the definition of escaping just punishment. We also have to recognize that the Supreme Court Justice Kennedy says that the reason why we have such extreme charges on the books sometimes is simply to use them to help convince people to exchange a testimony for a trial. So moving on to our subpoint C, the attacks the issue that innocents are going to be worse off in a world where plea bargaining is not legal. And this is because the courts will be more prone to errors because they'll have to compensate for the increased number of trials, the 20-fold increase in number of trials. In the status quo, there are safeguards. Judges have to watch out for cases that seem like an innocent person is being pressured into a guilty plea. It isn't as simple as she would like you to think it is, that people are being coerced left and right. And if we continue to allow plea bargaining to be reformed, this will get better and better. If we push it underground, it will get worse and worse. More and more people's rights will be sacrificed. Moving on to the negative side of the flow, the only attack that she makes in response to my value of justice is that I don't treat people equally. But what treats people the least equally, what is worse to the most disadvantaged groups in society in the status quo, is pushing plea bargaining underground. Because even though 60% of cases are still going to be resolved through plea bargaining, so all of the harms that she's talking about will still exist, the people who get the plea bargains are the ones who can afford the expensive defense attorneys, which means those groups who are marginalized and those who are socioeconomically disadvantaged will statistically get longer trials or longer sentences because they will be forced to go to a trial because they can't afford the plea bargain. Moving down to my first contention, her only response to my subpoint A is that we will allow criminals to walk free. But this isn't the case. This is actually what happens in a world where plea bargaining is banned, because dismissal rates increase by 21%. And that means that you have that 1 in 10 criminals who are just simply not getting a trial, who are potentially dangerous members of society, and they're being allowed to walk free. This is inherently unjust because then you don't have people getting a plea bargain or a trial. Their criminal act is not being addressed by society in any way. Just punishment is not being given by any way. When she talks about efficiency, she basically just says that just because something is necessary doesn't mean that it is just. But this is functionally different when we're talking about a justice system. In order for a justice system to work correctly, it has to work efficiently. Otherwise, people's rights will be pushed through the cracks, meaning that they won't be validated. A just system is one that works both correctly and efficiently, and this can only work in a world with plea bargaining. There are no other alternatives. 95% of our cases in the status quo are resolved through this means. We have to continue to allow it to become better and more effective at protecting people's rights instead of pushing it underground and only hurting society.
So this last speech is all voting issues. Are my judges ready? Is my opponent ready? Okay, let's begin. So before I provide you with 3 voting issues, we need to talk about what this round really boils down to. So in my opponent's last speech, she talked about pushing things underground, and she talked about how we need a justice system to function efficiently, and that's how we're interpreting justice. So the resolution at no point says that this is how we have to interpret justice, so unless she could prove that that's true, that's irrelevant. But also, we need to determine true principles of justice, like based on Kant's standards, in order to determine if the system is right and if making it efficient is worth it. And these arguments have continuously been non-addressed throughout this round. That's going to be a crucial point in making the ballot, because the framework that we choose is ultimately determines which impacts are actually relevant to the resolution, and Kant directly answers ought, while the negative prefers efficiency. So that takes me to the first voting issue, which is about inherency. So there's 2 important things here. My opponent talks about all the reforms that the Supreme Court has done and all the things that these justices have said that make it actually okay. But she ignores the coercion part of it, and she ignores the things that are inherent to it that cannot be reformed. You cannot reform the inherent harms of plea bargaining, and regardless of what the Supreme Court does, this is a crucial point. Plea bargaining is inherently unjust, and my opponent has continuously failed to provide for how plea bargaining is the thing that needs to be here in order to fix things, and not just because we have court backlog and this is what we've traditionally used, but then also how it will solve for these harms. And because I provided in my last speech how it doesn't solve for the harms because the neg is the status quo, it's not providing for the justice that the neg is talking about. And then secondly, underground consequences don't justify plea bargaining. My second voting issue is about coercion. This was completely dropped throughout the round. The only time that my opponent addressed this was saying that coercion doesn't occur to the degree that it does, but I provided several pieces of evidence that talk about how inherently prosecutors have disproportional power. The judge often doesn't get to review it, and the defendant makes decisions based on information that the prosecutor determines what they find. They don't have the full breadth of information, and they don't have the checks and balances of a trial. And if they don't have the checks and balances of the trial, then we cannot ensure that justice is being dealt. And we're becoming more efficient without ensuring justice in the first place, which is the central fault of the negative. It never explains why this justice system, why the current system being more efficient is the ultimate just outcome. It just wants to improve efficiency without a moral grounding. So the third and final voting issue is going to be about the justice system's burden. Yes, my opponent says it should preserve individual worth, but that's only occurring on the affirmative side of today's debate because it's preserving equality. So my opponent barely addressed this in her previous speech, but the Aristotelian justice values equality, and by nature in her subpoint A, she's saying that it's just to take down worse criminals by violating the rights of one individual. That's not equally upholding justice. It's violating individual rights, and because coercion was completely ignored and the fact that the waiving a right to a free trial is not actually being upheld in the negative world, there's no justification for plea bargaining needs, and we can't ensure that good consequences are actually arising out of an inefficient and unjust system. For these reasons, I must continue to urge a ballot in negation. Or affirmative.